Ron? Good morning. Welcome to today's court enforcement hearing. My name is Myrna Belrochin. I'm going to be your special magistrate today. This is a quasi-judicial hearing, which means it's like court, kind of like we see on TV or have you ever been in real court. However, the rules are less formal, and everybody who's here to speak on behalf of a case will have the opportunity to do so. At this time, I'm going to ask for anybody who's going to be providing testimony this morning and possibly afternoon to please stand up, raise your right hand for the taking of the oath. Do you swear from the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Okay, with that, I'm going to ask the town to please call the first case.
Good morning. Our first case today is Nature View Court LLC, 313-317 Nature View Court. The code officer on the case is Bill Stout. The case number is 2019-0653. To work without permit, the lower level remodel. This is a lien hearing.
Is it a rehearing or is it a imposition of line of certification?
Imposition of lien.
Okay.
Madam Special Magistrate, there have been ongoing communications between the town staff, my office, and the representatives for the property owner, and literally right up to the start of this meeting. And one of the things that was discussed, and I'll certainly allow representatives for the property owner to respond, but one of the suggestions that I made was that we move forward with, there's a basic agreement that the previously issued permit that you ordered the reinspection or access has not been complied with. There is a question that continues to exist as to whether or not some of the improvements that were made outside the scope of the existing permit eventually could or are permittable, and the parties have both sought input from the state and federal agencies that ultimately are responsible for assisting local governments with implementing the National Flood Insurance Program. All that said, the last discussion I had with representatives for the property owners that the idea of the parties agreeing to that the permit requirements have not been complied with, that technically the property is not in compliance, subject to further review. And so for the special magistrate to move forward with the certification with the instructions that city staff and town staff would hold on to the certification, not record it for 30 days or until the next meeting, to allow for a status report on whether or not some of the improvements could be resolved, and therefore bring it in compliance. And then at that point in time, we would have discussions with the property owners to what would, how long the property was or wasn't in compliance, which was part of the conversation, as you may recall. And I do not know, Mr. Dickerson and Mr. Lombardo were saying that they would get with their client and get back to us, and that was, 20 minutes ago. So I don't know what their position is.
Was this one of the in the last hearing?
Yes, yes, ma'am. It was.
Okay.
It's been around for unfortunately too long, involving improvements below base flood elevation.
Now I remember. I'm trying to recall. It's downstairs, upstairs, and then there was a garage, and there was a back remodel that was done, and then that was only cited, and then we were looking at the plans, and there were some improvements on different times. Okay. Back to speed.
And I don't mean to speak for Mr. Dickerson, who's at the podium, but the position of the property owner is that compliance was achieved when they applied for and were issued a permit. As town's position is that compliance is doing what the permit was issued for, and that the work that was approved in that permit exceeds the scope of the permit.
I remember that. Yeah, I'm up to speed with that because I remember now. All right, let me go ahead and hear from counsel.
Good morning,
Good morning.
Madam Special Magistrate Dwayne Dickerson, on behalf of the respondent, who's Nature's View Court LLC, attorney with the law firm Danae Misko and Backman in Boca Raton, Florida. So I do agree with Mr. Heron. We have been at this. We're working. Him and I and my colleague have been talking. So, you know, there's significant activity to try to get to the bottom of this. I also agree with Mr. Heron that there are some genuine questions and matters of dispute that I think we're really close to resolving. One in particular is dealing with the floodplain and what can and cannot be approved and what can and cannot be permitted. It's my understanding that the town has had conversations with the state floodplain administrator. We have as well. As you can imagine, we believe we both got two different answers.
Of course.
So we've asked the state administrator to put it in writing, right? So that we have some. So you know, my request is that we stay until we have these answers, because it really is critical to, I believe, the decisions that you need to make about when we received a permit. Was it the right permit, and then how does that impact what compliance looks like? Also, I'll tell you, but hopefully it will give you some comfort. There's really three things that I think are in play here.
Okay.
The first one was the order that said, come into compliance by any means necessary. We did work without a permit. So Mr. Heron's correct. Our position is once we received a permit, we are in compliance, okay? And we've satisfied that requirement. But to bolster our position, and I think to protect the town, you also said, too, you did not want the ground floor occupied.
Yes.
That has not been occupied. I've made it very clear for the record last time. I think the town would support us in their inspection that it has not been occupied, and we will maintain that until we resolve this. Okay, that's two. And then three was the third part about the inspection, and I know there was some concern from the town of being able to access and see, and that's taken place as well. So there are no life safety issues. It's not being occupied. We strongly maintain our position that we are in compliance, but in the spirit of compromise, I would like to get these answers so that we know that if, in fact, there's more work to be done, that we can get that work done and get this resolved. We have an active permit. Okay, our current permit is open and active. There's a list of activities that have taken place since we received the permit, and that's the town's records of what's been done. So at this point, I just respectfully believe that it would be premature to levy fines while we're actively seeking the right answers to get this resolved. So I will continue to commit to you that we will continue that activity, and hopefully we'll be back before you soon with the resolution of what can be permitted, and then really be able to just deal with what compliance looks like and when we did achieve compliance.
Yeah, I remember this, and it took us a while to go ahead and sort through them because there were permits and there was work. I think there was different permits also coming from the county that we had to review over. And then towards the tail end, there was some question about whether the last permit that was issued, whether the work actually matched what was in that permit, in addition to the whole, because I think that there was, I'm going to use the word suspect, but that probably isn't the best word. When comparing between the work that was done and the actual permits, whether there could even be that type of work done in the first place, hence why the FEMA map came into play.
Yes, ma'am.
And the state. Okay.
Yes, ma'am. You are correct. Now, I feel my client kicking me from over there because he's adamant about this suspect permit, and I don't want to really get into it too deeply because I think we're so close here, and I don't want to, take any steps backwards. But I will tell you this: the work was done without a permit. The work was completely done without a permit. Okay, and then we requested the permit to fully cover the work that was done. It was the town's position at that time that that permit could not be issued. Could not be issued for that scope because we're below. So what we did was we transitioned to a permit that the town said could be issued, which is the permit that you saw. But we have documentation. We've submitted the full set of plans of what was done and what we wanted a permit for. So I just want you to rest comfortably that it was never we were trying to hide anything. It was never that we got this permit that we knew didn't really cover what we wanted, and just we could kind of kick the can. We submitted a permit long ago of exactly what we wanted. The town wasn't comfortable issuing that permit, so we transitioned to a permit that the town was comfortable issuing. And I think once we get this answer from the state floodplain administrator, we'll have that answer of what we really can do and what permit is the right permit that the town should be issuing.
All right, so to the town, Mr. Heron, I'm looking at the notations that obviously I think everybody's in agreement that if we go with the city's argument, the property is not in compliance. There appears to have already been fines accrued today, correct?
That is correct. Where Mr. Dickerson and his client and the town diverge is that
The scope.
compliance isn't simply obtaining the permit, but rather removing the things that were either obtain a permit or remove the improvements that were made without a permit, and that's not happened.
So
And
if-
that's why the fines have accrued.
When I was gonna say, so if the fines have accrued to date and there's still, though it is not in compliance yet, and there's a dispute, I guess, as to the scope, what is the harm in just leaving the case as is, letting the fines accrue, and when the issue gets resolved, then bring it back for me at certification at that time?
Well, and that certainly is an alternative, as long as Mr. Dickerson and his client understand that the fines will continue to accrue.
Yeah, and then if it turns out that they're right, then we go ahead and consider that. We know, okay, so they're
And if
right
not,
as of this
then
date.
we'll at that-
And at that point in time, everything else drops out because by effect of law, it goes away. So my inclination at this time is
To
leave it
continue.
as is.
Okay.
Leave it as
We-
is when
You know,
it's-
if that's if
Because my
the
concern, like
special
you
magistrate
said,
believes that that's the best solution under the current circumstances, far be it for me to
so
question.
long as the property continues to stay vacant, which council has represented that they have been doing and will continue to be doing,
Yeah,
I
we'll-
think that's the
we'll-
better course of action and just leave
Look,
things as is.
I think that the town staff has represented throughout this entire process with everyone, and certainly with this property owner. We're here to help
Yep.
within what we can do.
course.
And so the question is, is any of the improvements that have been made to the below base flood elevation are permittable? That's what we're waiting to find out.
So yeah, and I think it's cleaner also because that way, at that point in time, when it comes back to me for certification, we'll actually have what the actual approved liens are. They'll have a pathway to get it resolved, and hopefully by then maybe he already has it
Right.
taken care of by the time they come back.
All right.
So my inclination is like, let's not touch it, let the fines continue to accrue. I'm sure he'll be watchful about what that date of compliance is going to be based on whatever the state determines. And get them back on the road to go ahead and get the
Yes, ma'am.
getting in compliance.
I would be remiss if I didn't say, and potentially the alternative, that you determined that compliance was years ago and fines have not
Correct.
accrued. So as long as everything's on the table, I think we're comfortable figuring this out and then giving you all the evidence that you need to determine
I
we
think
were in
that's better.
compliance years ago or fines have accrued and what that
Correct.
looks
Or
like.
if the city's right, I'm sure they'll let me know, and if it comes favorable to your end, you'll let me know what that date is, and then we'll resolve it at that point in time.
That's perfect.
Okay?
And-
Because at that point in time, it's a matter of when is the date of compliance, or what does the compliance look like,
Sure.
and where are we now?
Sure.
Okay, all right,
We're okay with that.
all right,
you.
so we'll leave it as is.
Thank you.
Thank you.
I'm sorry, Madam Special Magistrate, in terms of rehearing, I guess we'll work with the town, and then when we all think we're ready, they will reschedule it for another hearing.
Well,
in the
technically,
future.
it's not going to be a rehearing, and for their purposes, the ideal situation is that when it comes to me, all the facts should be there.
Perfect.
You should be in a better squared out. However, the town has the right at any point in time to go ahead and say, you know what, we're just going to move for certification.
Sure.
Because this is the date we have, and that's that. So.
And then we would be set for the next hearing, and you would have to.
Correct.
Okay.
My anticipation is that once that floodplain opinion comes back in writing, that probably then after that, the next hearing, you'll probably be on the agenda for the next hearing, so.
That sounds about right.
So
I
kind of
don't-
like
I
cue
don't-
it in, when you get it, make sure you reach out to the city and to see if you're on the agenda.
Yes, ma'am. As far as we're concerned, we don't want to or think the town will be in a position where they think they just need to move forward. I think hopefully we'll continue to be in a position where we get the
That's the
answers
goal.
that we need, and then we come back and see you together.
Here's, so we're all clear. Staff is the one that prepares the agenda and schedules it. We meet at this current moment. The meetings of the special magistrate are every other month. So the next meeting would be in August, and it'll be placed on the agenda. And hopefully before then, we'll have some certainty.
That sounds
If
good
not,
idea.
then we'll
Perfect.
we'll determine what the appropriate course of conduct is in August. But we do anticipate that we'll have an understanding at that point in time.
Yeah, reasonable. That's 2 months. You guys should have it squared out by next one. All right,
Works for
great.
me. Thank you.
Nice to see you.
Thank you.
Thanks, you too.
Thank you.
Next one?
The next case that we're hearing today is Matthew B. and Tricia Oakley, 280 Sterling Avenue. The code officer on the case is Bill Stout. The case number is 20220305. This is work without permit, lower level remodel.
Madam Special Magistrate, much like the past case, it's very similar. The order that the Special Magistrate entered was for the Oakleys to coordinate a meeting with staff to have staff make an inspection that did occur. And staff identified some outstanding issues that need to be resolved. A permit needs, essentially in the form of demolition permits. There are some improvements that are, in the opinion of staff, violative of the below base flood elevation regulations. There's some light fixtures. There's actually a breaker panel and some water and sewer connections that need to be capped, and the same with the electrical, removed and capped or elevated above base flood elevation, and that would be compliance. We took photographs during the inspection, and that's what we have to report. And do not assume to speak for Ms. Oakley or her counsel, who, as I've been informed, it was unavailable today, and Ms. Oakley is here on her behalf.
But was this one, this one's on the new cases list? Is it a new case, or was this before maybe?
It's a new case,
It's a
number
new case.
6.
Okay.
Yeah.
I apologize.
No, I do have it as number 6, but I thought
Okay.
I heard
Yeah.
him say reference to, like, I had ordered something.
You
that kind of thing.
continued it last month and ordered an inspection.
Okay, so I did hear it, I just didn't
Yes.
enter an order.
So we're back here reporting on the results of that inspection.
Okay, and what are the results of the inspection? Okay, so yeah, tell me about the elevation, the,
Correct, and so the
The
updated
electrical
information and the photographs of the inspection are in your
Yeah.
package that's been provided to you and entered into the record. As I said, there's a notation on the building plans that were submitted as to where the remaining issues are at. It's on these first pages and handwritten by Ms. Schumacher, and the photographs are, where are they? There.
I'm looking at that,
At
just
the-
most recent ones are attached to the, this
Yes.
plan view.
That should be here. In the folder.
Hold on, we're getting the photographs.
I remember it now.
Yeah, I mean, just the original photographs
This is the
that
one where there was-
are in the record, are, the condition of the property is different. A lot of the corrective action that would otherwise be required has taken place. They're still, and so what the new photographs show is very specifically what remains to be done, at least in the position of the town.
Should be in the folder. Should be in your folder.
Okay.
There. Come on.
I can pull up the case from online.
Oh, boy.
All right, let me hear from the property owner. Please state your name and relationship to the case, please.
My name is Tricia Oakley. I'm the owner of 280 Sterling Avenue.
Okay.
Come on, Bill.
And it sounds like you had a productive meeting with the city.
They did come out and look at the property at your direction or order.
All right, were you provided with copies of the sketch and the pictures that
No.
they took?
Well, just now I
Okay.
got them, so.
All right.
So she
Do we
had-
have a hard copy that
she's
you can
got it in
take a
her
look at?
copy.
I have somebody's file, so.
Okay, so you're able
Yeah.
to, like, you have it, okay, before you, okay. So it looks like, based on the inspection, do you have this one, the one that has like the blue notations? Okay, so those are the areas that, they've identified that would be at issue with the flood, with the FEMA floodplain. Has the state been reached out on this one also, or we just, at this point in time, it's
I
just?
mean, this one, as I said, based upon the inspection by town staff,
Mm-hmm.
it's pretty self-evident what the corrective action needs to be, what remains to be done. Again, from a practical perspective, the prior improvements that were put in place without the benefit of a permit, and I know that there's a dispute whether or not there was or wasn't a permit. It's obviously the position of the city that there wasn't a permit, or if there was a permit, the improvements exceeded. And there's those photographs there. Most of it was removed, unfortunately, by natural forces, that primarily being Hurricane Ian. But there are some remaining improvements. There's, as I said, there's a breaker box that is about chest high, obviously below the base flood elevation. There are some high hat and light fixtures, again, below base flood elevation. There's a plumbing connection and a wastewater connection that need to be capped. And the, what's the other one here?
My stuff I sent? I sent a pretty big file of Dropbox things, and so we'd have all the information this time for,
That
special magistrate.
That I do not have,
I did
so,
not get to pass it on because I got it when I was here. I'm just looking at it.
And
wait, just,
there's some framing that needs to be removed, and some interior framing. And then last but not least, subject to determination by the building official that they meet code, because there's, obviously some structural issues. The windows and doors that have been put in. And again, based upon the town's position, those potentially can be permitted. They just need to go through the permitting process and be reviewed by the building official to make sure that they're Florida Building Code compliant and meet all the requirements of the town code. But the other improvements can't be permitted because they're, again, below the base flood elevation. And so we're asking that the corrective action be their removal and their capping.
basically anything that would deem it habitable needs to go, and it should be only for services functioning for the top floor, not.
Correct. Obviously, the garage can have access to the outside for storage purposes or whatever. It just, we need the permits and drawings in order to be able to approve those improvements.
All right, so let me hear from.
Those have been submitted already.
So I was gonna say, you mentioned a package for Dropbox. What was in the contents of that package, since we actually don't have the
The
physical?
permit that, we have 2 uncompleted permits on right now from during this code violation thing over the last 15 months.
Okay.
And I sent the information through to, after the inspection, I've been working on it, to kind of get it sorted out. And over the last 4 or 5 days, I think I have sent the information through so that and attached it to one of those uncompleted permits that we had already applied for, that we really never got a response for, but and I think it is everything that's needed to apply for this permit to get it into code. But I'm assuming that we did pass our final inspections from after Irma, so.
Okay, so those were from prior, those were the ones from, I think, Lee County, right? You had permits from Lee County?
Yes, and I guess, I don't know, I requested all public information that pertained to our case because there was an issue with the, who had what and what records, and if they were here, if they were in Lee County, and who, we're talking about like 3 mayors ago, I don't know how many town managers, town attorneys, I know you weren't here, ma'am. And, you know, so it's very complicated. It's a long, complicated ordeal.
You mentioned that there is a permit that is open. And I heard you say something about a permit application you haven't heard back.
Right.
Let's start with the permit application. When was that permit application?
I have 2 of them. One is from May
Of this year?
of last year.
Okay, 2022.
And one is from August of last year.
And those are applications for permits, not actual permits, correct?
Exactly.
Okay. And you haven't heard back from either of them?
Right, so I attached what I sent this time because one of them already has the, I do work for a living, so it's tough to get all this stuff kind of done and do everything else. I attached the documents and I sent them to everyone of what was needed, and I basically used the plans from after Irma that we already had because that was when the work was done down there.
But the applications you told me are from May 2022 and August 2022. Is there any recent permit applications?
No, I
So-
have asked if that was gonna be okay. I've asked, you know, the town staff if it was okay if we just did that, so that, because my owner affidavit thing that's got the doc stamps on it is attached to one of those and all the information, so that way I could just email it or upload it, whatever needed to be done, and move on.
Do you have a contractor who you're working with?
We will likely use the same original contractor that we
Okay.
had before. The second contractor, the first contractor, we are
From
in-
2017?
Yes.
Okay.
The first contractor we're in legal proceedings with, I actually sat in that hearing yesterday for 9 hours. And so, you know, what happens with this case is very paramount for us with that also, so.
All right. And now, when it comes to the items that the city has,
So our
That-
second contractor, I'm so
Oh, go
sorry.
ahead, go
I'm very tired. Our second contractor was Eric Hewitt of Hewitt Home Improvement, and yes, he, you know, basically tore our house apart and re-put it back together from beginning to end. I have no problem supplying all those costs.
when
for
was
the
that? When was
cost.
that?
It was between 2018
Okay, so we're
and
still back in
2019.
after Irma.
So
Okay.
he will do the work again.
Okay, so you're thinking that it's going to be him. Okay. So from the city.
If we have to draw plans again, we will have to find a new architect because the person that we used was, he used to do it as a moonlighting position that we found out after we hired him. And his position where he works has become way too big and he doesn't have time to do things and all that kind of stuff.
These are pictures? Or
Yeah,
okay.
those are the pictures that are reflective of the inspection that took place a couple of weeks ago. As I
Removed stuff.
previously mentioned, you'll see that there's a breaker box, the actual framing that is holding the breaker box. There's also some light switches that are all below base flood elevation. There's a photograph of the window and the doors that, again, the windows and doors don't
I really
necessarily.
have to point out,
Hold on,
I'm sorry to
you gotta let him
interrupt you,
finish.
but I was
You-
in the middle of my
Hold
thing.
on. But he started going, and so you got to let him finish. and
I'll
then
let
I'll-
her finish.
Okay.
Thank you. So we, you know, I think our electrical plan, if you have the plan, the final plan, I actually never had that plan from 2019 that was submitted to the county, and I never had any of the information that Alan Weiss asked for from the county that would have, you know, gotten our cost card and all of those things. I mean, I'm happy to tell you guys, we spent over $400,000 putting this house back together after Irma and a contractor. So yeah, we're way over the 50% rule. But had we, you know, known that all of that was happening and we needed a bigger permit, we would have applied for that. We asked about it, it didn't happen, and, you know,
Right, so the concern that I do have,
the electrical switches and plugs that are down there are are part of that plan that was in 2017. It's on the final from February of 2019 that was submitted also. I don't understand what the hang-up is about the electrical. It's in the scope of work on the architect and engineer plans that's stamped off by Lee County.
I remember those, having reviewed those plans.
I mean, it's
last
on the
time.
plans. You guys have the plans.
The problem is that
The plumbing, you know, when we got this code violation from Bill, I asked, and several emails about plumbing and electrical. It was in the plans, and, you know, a simple communication from Bill or anyone that said plumbing fixtures, I would have like, oh, okay, yeah, there's a couple plumbing fixtures down there. But when you say plumbing overall in general, I think of pipes and sewer lines and cutoff switches for the water that come into my house.
Here is where it's for I guess and I understand. I guess I can understand the confusion regarding the fixture versus plumbing and the terms used. In basic terms, anything that would allow that space downstairs to be livable should not be there.
Right, so I'm pretty sure we're
So when you
in
have a light
compliance.
switch, how you comply? You have a light
Because
switch with
the
hi-hats.
the
You wouldn't have hi-hats unless you were actually making it livable.
But the electrical plan was in place when the plan was,
But it's
Approved.
going to have an electrical plan, right?
No,
Because
there
even
was-
if you have a garage, you're still going to want to have a light up there, and you might have even circuits that are running to feed up for the upstairs. So there's going to be electrical shown in the plans. That doesn't mean that the electricals actually showed for you to have receptacles and hi-hats in the downstairs.
although I'm pretty sure the way I read the plans, those electrical outlets and fire alarms and things like that in the scope of the work are on those plans.
So-
And if I'm wrong, then, you know, so be it, but at the best that I can tell, and I've asked for, you know, building folks from, we had Steve Strutter out to our, you know, was out there in between this whole 15-month ordeal also. And I've asked several times, you know, hey, I need some help. I'm not a contractor. I hired a contractor. I hired 2 of them, as a matter of fact. So, you know, if that is not part of the electrical plan, then I'm not really, you know, I guess we could call the architect and ask him if that was his intent on the plan.
It doesn't matter what his intent is, it's what's there and whether it's possible by code or not. So
Well,
it
it's
seems
there and it's on the plan. That is our resolution to it.
okay. So see, here's the
And if
concern that I
it's not
have.
supposed to be there, then we'll happily remove it.
Okay, so here is the concern that I have. When we had the last hearing, and again, I remember the case, and I remember the documents that were sent, which I was able to go ahead and read at that time and with the computer, and I looked at those plans, and I looked at them incredibly carefully. I mean, I think your case took over an hour to hear on during the last hearing, because I thoroughly went through all the
Right.
documents for Lee County, all the plans from that you provided. I went ahead and I compared them to what the city has, and there were items there when I was looking at it. I remember even telling your attorney right then and there, what you have there does not appear to be what was permitted by Lee County. Hence, my order for the inspection. Right? Because if I had been able to say, oh yeah, it's there, of course, she's complied, she got it from Lee County, done, she's got it. No, I was able to go ahead and see and say, yeah, there appears to be some discrepancies, let's go ahead and have somebody go out there. But again, when I'm hearing about hi-hats, and I'm looking at the hi-hats, and I'm looking at toilets and plumbing that would serve as a toilet, and plumbing that would serve as a
I don't
sink,
see
and
any plumbing on those
flaming-
4 pictures.
And framing that appears that it was intended to go ahead and break it out for livable space, I get concerned.
Is it livable space or storage and garage area? I mean,
And it's
You know, it's
and
a
it's,
very-
it's the, that livable space that becomes an issue. So
I
so
don't-
again, you keep saying, oh, it's permitted and this and that. It's like, when we're
Okay.
talking about that floodplain, we're talking about
is it not
a concern about making livable space where there shouldn't be. And with the experience that Fort Myers Beach just had with Hurricane Ian, when flooding was the issue, I mean, it's very hard to be having this conversation with you right now. You know what I mean?
Nobody knows better than we do. We've fixed that downstairs 3 different times since Irma. and one time before that.
So it
before
seems
Irma.
like since the last hearing, after having raised my concerns, because I remember I raised them there, I think by now everybody knows that I kind of blurt it out, like sometimes I can't just hold it. I even pointed out the areas of concern, hence the reason that I sent the inspection, but it doesn't even sound that you've hired a contractor who would be the main person that would help you.
We have a
Get through it.
contractor, it's the same contractor we had before. He's not gonna come
I
in
thought
there
you
and
said-
touch anything until this is settled.
Do you have a contract with the contractor?
No, I do not. I don't even have any money to fix this right now. How would you want me to do that? Our insurance money is tied up with our mortgage company because we don't have a permit. We don't have anything to show our mortgage company, so they're not gonna release our insurance money, which is, pretty,
And what would
pretty
you
big
need,
amount
and
of
what
money.
would you need to go ahead and get that permit issued?
I need this settled so that I can get the permit or I can apply for whatever so that they'll release funds to me to start the work. Our contractor's busy. He's got work from Marco
Ma'am, all I'm
to
hearing
Punta
is
Gorda.
excuses, is from one thing to the other, and I understand the whole concern about the issue with the money, and that was the same thing that we had last time, that existed already there. This is what the city wants, is compliance, and what I'm hearing
I
from
don't-
you is excuses. I don't feel like doing it because I already did this in 2018, it's permitted, so I'm not gonna do anything.
I don't think that that's the case at all.
So
I
tell me,
think that the
what?
preparation
Okay.
of work I did for this hearing and the 15 months of emails that I've sent to everybody proves the fact that I am not sitting here saying I'm not going to do anything.
So what is your
I think that
plan
you should
going
look
forward?
at that and that when this is resolved,
How is this
going
gonna
to
get resolved if you still don't have a contractor to get a permit? You haven't
I'm
applied for
not
a
going to
permit.
sign a contract with a contractor. This would not financially be feasible for me or to my advantage to sign a contract with a contractor that, and I don't have any money to even get it started.
Well, but that's a different story than telling me, oh, it's already permitted because this was by Lee County and I did all this research, and these are, if you come up front and you say, listen, this is what's going on, the city can help you. All they want is compliance. I mean, and they understand that people do need to work. People do need to live. It's expensive. But when the response that I seem to be getting here today is, I've known about this for a long time, and I'm still going to argue that it's part of the 2018 permit, is really not going to get
Actually,
you far.
what I knew for a long time was after they came out to the property and looked at it and said, okay, this was here, this wasn't, because I never got the final request from Lee County of what needed to be changed and done to get the CEC, their CO, for the permits, for the remodel permit and everything else. I never got that. So we didn't know that it had to be brought up to complete FEMA compliance. Those emails are available. I've gotten them through, all those communications were done between Lee, the town, and,
But again,
I'm happy to share that information with you. I did submit all of it this morning to be used.
I'm not.
If you're going to deny that, to even look at this or show me on those final approved plans where the electrical is not part of that.
We did this last hearing.
No, you didn't.
Of course we did.
You
You
only-
sent those documents by email. I was in my office on my computer, and I spent
Yes, and you
A
said
long
the
time
electrical
ago,
plan
yes.
was down there. I'm happy to go through it again. 'Cause I think
Well,
we
it's
have
not for
some
you to
lack-
go through them. I mean, you can go through them all day long if you want. Have them as sleep time reading material. It makes no difference to me. My concern is that there are no steps going towards compliance. And if you have a confusion regarding what Lee
There
County
are
said,
steps
what
going
the
to-
cities tell,
I
ma'am,
want-
I'm talking.
Yes, because you're.
I'm talking, ma'am.
What?
But it doesn't seem like it's coming. It's. I don't think that you're understanding, or you don't want to understand, and that's the problem I'm having. So like I said, if you came up front and you said, "Listen, money's tight. This is an issue," blah blah. No, but instead you're taking an antagonistic position that does not match the documents, and does not match the ordinance. And everybody's trying to work here with you,
I
but you
applied
don't
for a
seem
permit.
to be wanting to listen to what people are telling you in order to get this resolved.
I applied for a permit. I've turned
Okay.
in all the
So
paperwork.
this is, I'm running in circles now. What is the city requesting?
I mean, I went through.
Ma'am, I'm done hearing to argument. I've tried, I'm at the ruling stage. What is the city requesting?
So the city's position, so it's clear on the record, and it's in the materials, and the information has been provided previously to Ms. Oakley and her counsel with regard to the 2018, 2017 permit application, is that, and it's been provided, and it's in your package, an application was in fact submitted to Lee County. However, if you look at the actual plans that were submitted, they don't show any improvements in the downstairs area. At some point in time,
It did have some.
They did appear.
It did have some, but it wasn't what's there.
And on the sheet that's part of the record, and the property owner has a copy of, on February 15th of 2019, the county issued a revision form.
I have a copy
Excuse
of
me,
that
ma'am.
now.
Okay, so you have a copy.
Go ahead.
And it says, and I quote, "All AC, plumbing, electrical equipment to comply with floodplain elevation requirements, AE 10 plus, 11 NAVD. Provide hydrostatic relief openings subject to field inspection, all related to compliance with the flood regulations that prohibit any livable space or livable improvements below base flood elevation." Furthermore, in the materials that were submitted by the applicant's own architect, they indicated on the plans that all of the electrical and plumbing improvements that were shown on the first floor, on the ground floor, were going to be moved to the second floor. That's obviously not the case. So that is the position of the city. The city believes that it has demonstrated through competent substantial evidence that the property owner is in violation of the city code as cited in the notice of violation, and would ask that the special magistrate enter an order to that effect, and in that order also specify the corrective action that the property owner needs to take, which is obtaining a demolition permit to remove the materials that have previously been testified that are still in violation of the regulations, and submit and obtain a building permit for the improvements that can be permitted, namely the doors and the windows, all within what the special magistrate believes to be a reasonable period of time. Given the circumstances, the town is not adverse to giving the property owner up to 90 days to come into compliance. So we're clear, so we don't have this discussion again in the context of the previous case. It's obtaining the permit and implementing the requirements of the permit within the 90 days, not just applying for the permit.
Well, when I get the things that I need to do back, I'll do it. You know, I didn't know what needed to be applied for prior to these folks coming out to the property and going through it with us. And we talked through it, and I've submitted that since.
What's the per diem?
We did the tour a week later after the hearing.
What's the per diem?
I'm sorry?
Per diem?
The town is asking for $150 a day for each day of noncompliance.
Okay.
Given the length of time and frankly, in our opinion, the easiness, I don't know if that's the correct word, which to take the corrective action.
All right, and the fees, is there a request for fees and
Yes,
costs?
and the request for imposition of administrative fees and costs in the amount of
$250 per case?
$250 per case. We have two cases, special magistrate, all relating to the same violation.
Yeah, we did have the hearing last time too, so.
So within your discretion.
So my inclination right now is to just leave it for compliance without providing the specifics, even though the town just gave her the benefit of of what it's looking for compliance, in terms of compliance. Just because, again, in terms of that building permit, that is her option. She can choose to come into compliance whichever way she wants. So that's why my inclination is to go ahead and just do compliance. That way she can come into compliance whichever way
Okay.
she wishes. All right. All right, I hereby find that the violations stated in the notice of violation did exist and continue to exist. I'm hereby ordering the property owner to come into compliance within 90 days, otherwise specifying of $150 a day until the violations are corrected. And I'm also granting the city's request in the amount of $250 for fees and costs incurred in regarding this case and bringing it to magistrate. All right, so we're gonna have the second one.
So the 150 starts today?
No, 90
Oh.
days. So if
90 days.
from 90 days starting today, 90 days starting today, and hopefully if you engage a contractor, or you decide to work with professionals, and you definitely want to stay in touch with your code officer, if there is a need for additional time, because you are moving towards getting compliance, if you stay in touch with him, he'll go ahead and so long as things are moving and it's not a request because I just sat and did nothing, so long as you're moving towards compliance, the town will work with you in giving you additional time if you need it, okay? But the first step is getting this order and giving you the 90 days, and if you just sit on it and wait till the last minute to go ahead and do what you need to do, then a request for extension is gonna come to me and I'm gonna deny it. So again, so long as you're working towards compliance, I'm happy to go ahead and get that extension if it comes before me.
All right, thank you.
All right, so we have the other case that needs to be called. Did you do
This,
them
the
both
next
at
one's the
yeah.
case,
Don't leave, ma'am, because that's the same. Oh, did you do them both at the same time?
yes.
Okay.
But I didn't mention the case at the same
Yeah,
time.
okay, call the other one, because then how are you going to split them? Because
Yeah.
they're two different case numbers.
The next case is case 2022-0707. It is a continuation of the previous case. They were previously citations. So Trish and Matthew Oakley are the property owners at 280 Sterling.
All right. So once, they're both cited as work without permit. The other one.
It's for the same, essentially, they're the same things. We started a hearing first, we had citations, and the hearing came, so we started a new case because we couldn't get the new citations on a hearing. But so far, the hearings have been continued until today's date.
Special
But,
Magistrate,
yeah.
may I make a suggestion?
Yes, please.
That the city will withdraw the case that is cited as 2022-0305 and substitute, and substitute in its place and the ruling to case 2022-0707. The first case is the one that cited or involved the citations. The second one is the more traditional
the
notice of
citation.
violation,
Okay.
which is the facts are the same, and you just entered an order granting or finding that the violation exists and ordering the property owner to come into compliance with a certain period of time. And we're okay with that, and we'll waive the citation case and withdraw it.
So we're gonna go ahead and proceed under the 707 case then, right?
Correct. That's the one. that
Okay,
involved
so
the
just for purpose of the record, the order that I just entered in relation to case number 2022-0305 actually is going to be the ruling for the case number 2022-0707, and I'm gonna grant the city's dismissal of that 2022-0305 case, leaving only that 2022-0707 as the only open case.
Correct.
And the
so-
order is going to be based on that 707 case. Okay.
And what I would say to the property owner, so she can convey this to her attorney to the extent that she communicates with him, is that there was a question about the first case that has been withdrawn by the town is where all the fines had already accumulated because they're issued on citations. So we're withdrawing that. So there's no, excuse me, ma'am, let me finish. So there are no outstanding fines that
Under the
have
new
been
case.
levied against the property owner under those citations. We're proceeding with the order that was just entered by the special magistrate that would only start accruing fines if and when the property owner doesn't come into compliance.
Got it. Okay. Yeah, there's gonna be an order. It was just a ministerial issue because you're appearing in two different case numbers. So one's gone, there's only one open case against you. That's it, not two. Yeah. Bill, does she,
All right.
Bill, does she have your contact information, a card for you? Because you're the court officer on this.
Yeah,
one, right?
we're in constant.
Okay, perfect,
Yes.
perfect. Stay in touch with them, they'll give you guidance
it to you.
and where to proceed, and the order will be in the mail. Okay, thank you.
The next item on the agenda is number 8, Thomas Swanbeck, PA. It is a sign without a permit case at 2450 Estero Boulevard. The officer on the case is Patrick Morris. Case number is 20230613.
Good morning, Your Special Magistrate.
morning.
My name is Patrick Morris. I'm code enforcement officer on the town of Fort Myers Beach. I've been a code enforcement officer since April. This case that I'm bringing before you now is a sign without a permit. It was first inspected in March 28th of this year. And on that same day, we sent a notice of violation, we certified, and it was claimed. We posted it on the town, and we posted the property for the notice of violation. I'm sorry, but on May 3rd, I inspected it. I took over the case at that time, and I inspected it. And on the 8th, on May 8th, we sent a notice of hearing, certified and was claimed. We posted it on the town website. And on the 22nd, we posted on the town website. And on that day, I spoke with a couple of people that were in the trailer, gave them my business card and explained to them that, if I could talk with the owner so we could see if we could settle this problem before it got to this. Mr. Schweinbeck, I spoke with him. He did apply for a permit. It's in the citizen site right now. It hasn't been reviewed by our permit department at this time. So he is applying for a permit for that sign. The town is asking for 30 days for compliance and $250 a day every day after non-compliance, plus $266.54 for administration fees, and before the release of the lien.
Right, how backed up is the town in regards to permitting?
That's hard to say. It could be 30 days. It's hard to say. We have new people doing permitting right now, so we are speeding up. They just came aboard, so it's hard for me to tell you exactly when.
Is the sign still up?
The sign is still up. Yes, we do have photographs of the sign still up.
Have it. And when was the application?
The application right now is in the citizen site. So,
When was it applied for?
just
He might know.
yeah.
I have it.
I think it was
Got it.
on the not like last week or something. Like we have another case for his deck up next.
Okay.
And I
Which
have-
one? The sign?
I think it was on the
It-
12th.
On the 6th it came in.
On the 6th, okay. All right, anything further from the city, from the town? All right, let me go ahead and hear from the respondent. Do we have anybody here? Oh, you're right. Come on up, state your name and relationship to the case, please.
Hi, my name is Thomas Swanbeck.
Okay, and this is in regards to a sign you have up without permits, and you've applied for the permit last week. Sign still up?
Yes, it is. The mistake that's been made is the existing
Oh, could you,
sign.
oh, yeah, go ahead.
Can you,
Yeah, go ahead.
it's the existing sign that was there before the hurricane. And what happened was, is it got pulled out of the ground to reface it because we changed, we were doing, office share with the Chamber of Commerce, and we now have an office share with the Lair Builder, so we put a new face on it. They took it out of the ground, refaced it, put it back in the ground, and that's
That was the
where the whole
problem.
mess started. And I wasn't aware that we needed a permit to do that, but I'm aware of it now. So I'm hoping the sign is in compliance, we just get the permit and.
Yeah, it sounds like it's just a permit. You were just cited for the permit and you applied for it, yeah, already, so I'm trying to, make sure that you can get it during that time period. I'm gonna do it I'll do it for the 30 days, like he requested, but obviously if he needs additional time for whatever, because that's out of his control. So
Yeah.
if he gets it approved or not, so,
Yes, yeah.
definitely stay in touch with your code officer, that you see the 30 days come by and you still don't have your permit. Obviously issuance is when you pick up the permit. Where are they picking up permits nowadays?
I'm sorry?
Where are they picking up permits?
It's online.
So now
We're
we're-
actually Town Hall's 2545 Estero Boulevard.
Okay, so they have to still like physically go pick it up to just get it
Everything's
online?
online.
Okay, good. So that makes it a little bit easier. At least you get additional online. So just watch out for those 30 days if you need
30
additional
days
time.
starting
And-
today?
Yeah. But again, you heard me say, if for some reason there's a hiccup and you need additional time, just give them a call and,
Okay.
because that's not your fault, you applied, so. All right, so I'm gonna hereby find that there was proper service and that the violation is stated and the notice of violation did exist, continues to exist. I'm gonna order the property owner to come into compliance within 30 days. Otherwise, pays a fine of $250 a day until the violations are corrected. And I'm gonna grant the city's request in the amount of $250. Actually, this is the first one. I'm gonna put it for 100. In regards to fees and costs incurred by the town in getting this matter to magistrate, in regards to this case. So I'm just putting 100. All right, thank you. Next case?
Sorry.
So, Special
Oh, he
Magistrate,
has another one.
there are two violations for this property.
Correct.
So we're gonna hear the second one.
Okay,
Second, again, Thomas Swanbeck, 2450 Estero Boulevard. This is for a deck without a permit. Case number 2023-0612. Patrick Morris is the code officer on the case.
Special Magistrate, this case is for a wooden deck that was built to the trailer on 328. Was the first inspection by a previous code enforcement officer. On that same date, on the 28th, a notice of violation was sent certified. It was claimed. We posted on the town the notice of violation, and the notice of violation was posted on the property. On 5/3 of 23, I took over the case and I did a reinspection of the building. And then on the 8th, 5/8 of 23, we sent a notice of hearing, certified, and it was claimed. On the 8th, I did another reinspection. I spoke with the people in the trailer again and gave them my card and asked that the homeowner contact me so we can get this resolved before the hearing. On the 16th, the property was posted with a notice of hearing. Now, they did apply for permit number 23425. It was submitted on 6/12 of 23, and they're waiting for a payment in order for it to be reviewed. The town is asking at this time for 30 days for compliance, $250 a day every day of non-compliance, $266.54 in administration fees.
now when you say that it hasn't issued because of,
Yes, it's waiting for
because of
payment.
payment?
And when he submits the payment, it'll be reviewed and then issued if everything is good on it.
Okay, so he's technically then still at the application
Right.
stage?
Right. Right now, it's in the waiting for payment stage. So once he makes the payment, it'll go, oh, I'm sorry.
Then
it'll-
that's when it gets reviewed and then.
That's when it gets
that- okay.
reviewed and it gets issued.
All right, it's not the final payment for pickup, for
Right.
it to be issued, okay. All right, let's hear from the property owner. State your name and relationship to the case, please.
Thomas Swanbeck.
Okay, and, all right, so it looks like it's just the payment is missing for it to go get reviewed.
Correct. I was shocked when I got the invoice for it. Permit fee is $1,662, I
After the
believe.
fact?
Pardon me?
It's after the fact permit, because you built it without the permit.
That, I believe, yeah, that would be
So
correct.
that's the, I think it's 3 times the regular price.
And this is our building was washed away from the storm. This is a temporary sales trailer. So it's just simply a wood deck that's not attached to the trailer. And I didn't realize we needed a permit for that. I do now.
The irony of it is that you have a contractor there that should have known that was needed a permit.
Yes, yes.
All right.
And so it's just, the reason, I didn't pay it because it was like, wow, that's
Yeah,
way more than what the deck is worth.
yeah, well, I mean, removing it is an option.
Would it work to remove it and then apply for the permit?
Sure.
And it
I
would
mean,
be
I mean, that's, you know, I mean, I don't mean to be, you know, dismissive or, it's up to you, really.
Yeah.
You know, whether or
Yeah.
not you wish to remove it and apply or pay the double permit fee, you know.
I think it's triple.
Three
Yeah.
times.
Or the,
That's why I do my orders that say compliance, that way you can
Correct.
pick and choose whichever way you want to do it.
Yeah.
Because there's
So
more
it's however you wanna
than
do
one
it.
way.
Because it's simple. It's like
Yeah.
5 or 6 guys can pick it up.
Now, I know some jurisdictions do require a demo permit. There's few, but I do some
yeah, I don't
jurisdictions
know
do
what
require the
would
demo
be
permit.
required. I mean, obviously, you know, it's, I mean,
Can we have a copy?
therein lies part of the issue of why a permit is required is, you know, Mr. Swanbeck has indicated that it can just be picked up and moved. Well, that's an issue because it's not securely attached.
But he's,
to the ground. But that's-
he's kind of
that's
falling on the sword on it.
How he
so.
comes into compliance
Yeah.
is up to
Yeah.
him.
Yeah. And then again, just to make sure, we have court officers here, he doesn't need a demo permit, right, to do this, to remove it? No? Okay.
Good question.
Going once, going twice. If for some weird reason you need a demo permit, just come back, I'll give you extra time to go ahead and get that done.
Yeah.
But it sounds like you don't, so, yeah, removal will be an option. But again, like I said, my order's just gonna say compliance, so you come to compliance whichever way you want. Okay? All right, I hereby find that there was proper service and that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby going to order the property owner to come into compliance within 30 days, otherwise face a fine of $250 a day until the violation is corrected. And I'm also granting the city's request for fees and costs incurred regarding this case, however, in the amount of $100. All right, and you'll get an order in the mail.
Okay, thank you.
All right, next case.
Sorry, I'm still writing. Are
That's my
both you
dad.
gentlemen here for a certain case?
No, that's my dad.
Oh,
He kept me company today for 2.5 hours
oh,
on the drive.
today?
Yeah.
Oh,
Did you
nice.
see the resemblance?
Next one on the agenda is number 11, Judith Canary. She is 5840 Lauder Street. It was demolition without a permit. The code officer on the case is Patrick Morris. The case number is 2022-1185.
Thank you, Your Magistrate.
Oh,
So we skipped 11 on purpose?
Yes.
yeah, I accidentally, I can't see very good.
Also, it was not on purpose.
No.
Okay, let's hear this one. The 11.
Okay, thank you, Special Magistrate. This case I bring before you, on December 5th of '22 was the first inspection by a previous code enforcement officer. On the 5th, also, a notice of violation was sent regular mail. A notice of violation was sent certified, and it was claimed, and it was posted on the town website. On March 7th, on April 25th, I took over the case, and I re-inspected the building. This is a demolition without a permit. The house was taken away by the Hurricane Ian, okay? So, I re-inspected it on the 15th of May. A notice of hearing was posted on the town. An NOH, notice of hearing was sent, and it was claimed certified. On 6th of this month, on the 7th, I spoke with Mrs. Carney, and she explained to me that it would be a hardship for her to be here. She's vice president of a college, and she will not be able to make it because of things that are going on at the college right now. I do have emails in there from her, and I also spoke to her on the phone. She spoke to a previous code enforcement officer. I do have that in the case also in your folder, where he spoke with her, telling her, spoke with homeowner Judy Canary, and her phone number, advised her that she could apply for a permit online through the town's portal. I informed her that she had 30 days to do so, and there is no fee for the permit. Additionally, I advised her to contact me should she have any issues permitting the process. She sent me an application for a permit for the demolition that we never received. She said that she sent it twice, one time in December of 22 and one time of March of 23. I do have a copy of that permit application, but we never received it, so it was never submitted. So I spoke with her, and she explained to me, and she also sent me an email that I explained to her that I would help her with any way that I can go through the permit process. If she had any other problems or anything. As of today, there's still no permit that has been even submitted to us.
Madam Special Magistrate, this is one of those that is really pretty easy in the bigger scheme of things. All we need is a demolition permit and her to verify that she's capped her water and sewer connections, so they're not active and they're not a health hazard or situation there. The structure itself and the improvements have already been removed, but the final step that we require under our code and under our regulations is for the capping and disconnection of those services, so they're not out there, and that's what we've asked and advised her that she needs to do, and we're here waiting.
And yet, that's exactly what I explained to her. That's all that we needed, and I would close the case.
Yeah, it seems like she has been provided more than once the instruction, and for X or Y reason, it's just not going through. So, seems like 30 days to go ahead and just get it through.
Yes, Your Honor.
Per diem?
So we're looking for 30 days. After that, $250 a day of noncompliance, plus $292.13 in administration fees.
And we don't have here anybody on behalf of the
No,
property owner?
no.
And I do see that in my package did include 2 emails from the property owner in which she advises that one of them reference to the hardship about being here, and the other one in reference to the 2 permits that she attempted to submit in December 2022 and March 2023. All right. But I hereby find, based on the evidence presented, that there was proper service and that the violation as stated in the nursery violation did exist and continues to exist. I'm going to order the property owner to apply for that permit within 30 days, otherwise face a fine of $250 a day until the violation is corrected. And I'm granting the town's request for fees and costs incurred regarding this case and getting it to magistrate, however, in the amount of $100.
Thank you.
Thank you. Next case.
Sorry, I'm still writing again.
Sorry.
Gotta write the orders. We're gonna go back to number 10. Property owner is Dennis Prock at 8124 Estero Boulevard. This is work without permit for the lower level enclosure, the repairs after Ian. Code officer on the case is Patrick Morris. Code case is 20230476.
Thank you, Special Magistrate. This case I have before you now is a case of a lower level enclosure without a permit. The walls were blown out because of the hurricane, and he replaced all the walls and didn't get a permit to do that. On 3/9/23, there was a site inspection by a previous code enforcement officer. On that same date, a notice of violation was mailed certified and it was claimed. On the 11th of that month, an NOV was posted to the town and was posted on the property. The notice of violation was posted on the property and in the town. On May 4th, I took over the case. I did an inspection. We still didn't have a permit at that time. On the 8th, we sent out a notice of hearing, certified, and it was claimed. We posted on the 15th, we posted a notice of hearing to the building. On 5/26, we received a email for an application, and we posted the property. On 6/11 of this month, I received an email from Mr. Prock. He wanted to postpone the hearing because his wife is in Muffin Cancer Center, and she has cancer and she's very ill. So he wanted to postpone this. I spoke with Mr. Prock. He came into the office and I spoke with him, and I had the permit department meet with him to go through the permit process and apply for the permit for this. Mr. Prock sat with our person. I looked over the permit afterward, and there was a bunch of things that he had in it, but he didn't have what we needed for this violation. So I sent him back to the permit department, and they sat down with him. But as of today, there's still no permit submitted to us. So we're still waiting on that permit. The town is asking for 90 days for compliance, $250 a day every day for non-compliance, $250.26 in administration fees. And I have you the emails that he sent us about his wife, and so I'm just waiting for the permit to be submitted at this time.
Was the downstairs being used as habitable space, or they just put up the walls and?
Yeah,
not-
the violation is for the walls. When we took pictures after the hurricane, the walls are blown out, and now there's walls all the way around it.
But
So
do you know
that's-
whether it's been occupied, that
No,
downstairs?
I do not
You
know
have no
yet.
knowledge about that, okay. And do you know whether that was habitable space beforehand?
Oh, I
I
do
mean, it's hard to say.
Yeah, I do not know.
It's a post-firm structure, so it shouldn't have been habitable space.
And that's where I'm going with it. It's-
Yeah.
So. Mhm. So right now, as far as the town knows, it's just those walls that would now.
Yes, that's, the violation right now is just for the lower level enclosures, and he is applying for a permit that he has other things on. Just, he didn't have this in order for me to close this case. That
Have
was
you
not on the
seen,
permit.
did you see what, the other stuff that he was actually trying to apply for, like the
I
drawings?
looked at the permit, it was some electrical work, it was some plumbing work, and, some remodeling upstairs. The
Okay,
lower
so-
level, right, the
Okay.
lower level was not on that permit, which is what I needed to close this case.
Okay, so it had nothing then, what you got had nothing to do with the violation then?
It had nothing to do with the
It
violation.
has something completely
And
different.
and he was in the office at the time, and I told him that, I said, you gotta get this on that permit in order for me to close this case. And then I handed him off to one of our permit people who was sat there with him and went through line by line how to fill out the application. He's an elderly gentleman, and,
Mm-hmm.
you know, and, so they were filling out the whole application, and, it just hasn't been submitted yet.
Now, one thing that I've noticed, because I'm reviewing the emails, the email chains. He also mentions that he's tried twice to get it through the portal and it's not going through, which is the same thing that we had in the previous case.
Yes, and I
So it
forgot
might
to
be a
mention
good
that.
idea for somebody from the city to go ahead and try to submit a dummy permit through the portal and see what happens. Because there
Yeah.
could be a problem with the system.
I understand that, Your Honor, but since I've been here in April, these are the only two cases that I've
Okay.
heard that,
How about that
that,
issue?
that people are submitting them online or they're coming in and they're not getting in. I haven't heard it on any of my
That
other
is true,
cases.
because the gentleman earlier with the sign and the deck, he was able to submit them.
He was able to submit
That
them.
is a good point.
And right now, I'm probably 200 cases in right now, and they're all getting in. So that
Okay.
they're flowing pretty steadily, and they're getting approved. So I don't know what the problem was. I mean, this gentleman, a very nice man, I think that maybe he didn't know how to do it online. The other one, the vice president of the college,
Yeah.
I'm sure she knows how to do things online. But this gentleman, maybe he just didn't know how to do it online and couldn't get it done. So that's why he came down to the office, and that's why we assisted him.
Now, I'm gonna
in
ask you
getting
something,
permit.
you might not know the answer to this, but is he working with a contractor?
No, he was pulling the permit himself.
Yeah,
The permit that he was doing, it
It was
was in
owner
his
builder.
name. He was owner permit,
yeah.
which it would probably not go through anyways.
Exactly my point, exactly where I was going. Exactly, because
And-
if he's got
and
that
he was advised to get a contract. I advised him that
Yeah.
he needs a contractor for this permit. So he was advised of that,
But we can't, obviously, we can't force him, we can just suggest.
but,
All right, it seems like.
and I have pictures of contractors at his house working, so, that's where we're at with that.
Is there anybody in the property when you went there?
Yeah, he's in the property.
He's in the property?
He's in the property.
So the cancer treatments are being done locally then?
Yeah. Moffitt Cancer Center. The Muffin Cancer Center?
Yeah.
In Tampa.
Okay.
Probably bathroom. Phone call.
Because the concern I have is, I mean, he's elderly and he's dealing with a sick wife. That's even 90 days. That's going to be.
Yeah, and I mean, I'm totally willing to help him any way I can, walk him through the process if it's not.
Yeah, that's what I'm thinking about giving him 6 months just to go ahead and basically having you just kind of keep tabs on him just in case something
Yeah,
happens. that-
absolutely. I'll definitely, I'm gonna call him after the hearing and tell him where we're at and find out how I can help
Yeah.
him through the process.
Because it might be one of those things that can go through very quickly. It might be simple to us, but sometimes when you're in that kind of place in life, it might be both with age and sick spouse, that could be a problem. All right, all right, I hereby find that there was proper service, and the violation as stated in the notice of violation did exist and continues to exist. I'm going to order the property owner to come into compliance within 6 months, otherwise face a fine of $150 a day until the violation is corrected. And I'm granting the city's request for fees and costs incurred in regarding this case and bringing it to magistrate, but in the amount of $100. And obviously, just check up on him and work with him
I
in
will.
terms of getting this through. Because I think he'd be better served with getting the contractor, but again, we can suggest.
Okay.
All right?
Thank you, Special
Thank
Magistrate.
you. All right, next case.
Next case we have up is item number 13. Robert F. and Linda S. Lynn. at 278 Ohio Avenue. This is another demolition without a permit. Bill Stout is the code officer on the case.
Okay.
It's reference, or code case number 20221311.
I'm Bill Stout, representative on the case. As your folder will show, the information's in the case. I did observe on December 13th, a contractor working on a demo of a building. I talked to him, he contacted the owner of the property, via cell phone. I spoke to the owner. He was on his way driving to his home, his northern home, and I spoke to him about the situation, and he said he would do it, but he had to get to his destination. And the last document in the case shows the activities that have occurred since then, which is basically a permit has still not been applied for.
Since December. And this guy didn't, no email, no
No contact from him whatsoever.
contact, no anything?
Now, he does have a person here, Frank,
Okay.
who he had just got contacted this morning. He was on site doing the demo with another contractor, and he has spoke to him, and I do not know if you want to hear from Frank.
Yeah, I think he needs to be sworn in, but yeah, we'll hear from him. All right, coming up, raise your right hand, because I don't think you were sworn in. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Absolutely.
All right, could you please state your name and relationship to the case, please?
Frank Kaiser.
Okay, and what is your relationship to the case?
Pardon?
What is your relationship to the case?
I just worked for the guy for a little bit to help demo the place.
Oh, okay.
Right, and that's about all.
All right, so it's just a matter of pulling out, it's gone, it's completely gone, right? So it's just a matter of capping.
They did a partial on the demo.
Right.
They left the carport and a small building, which I believe the electric comes into that building.
Yeah, it was a garage and a carport that he indicated, he said he wanted that left there because he was gonna bring a camper or something temporary, something like that. Anyways, that's the way he had it left, and then as far as, since I had spoken to Bill outside, he had said he'll take care of it, so I spoke to him, I said, listen, so I just got off the phone with him about an hour or so ago, and I texted him, I said, listen, this is what needs to be done. He said he did apply, and I'm like, well, it either went through or didn't. You said, I'm neither here nor there. I said, my point is that, Bill had informed me, because I was here at 9 o'clock, something like that, anyway, that it needed to be done online, so for so on. So I've been texting him back and forth, and I just shown Bill what I texted him. I said, listen, if anything, please get on it right now to show that you're actually complying and trying to do all the above, so.
Now, is that partial going to fly? Partial demo?
That will have to be known, once he applies for the permit.
He has to apply for the permit, because it seems to me that at that point in time, he's gonna need an engineer to certify that that's still structurally sound with the portions that were removed.
Absolutely, I agree, yeah. I mean, I'm not sure.
Either that or the whole thing
I
goes.
mean, we were informed that he had told us that he already had everything under control concerning permitting. Well,
Alrighty then.
and he's out in, I believe, Pennsylvania, or that, I forget.
Looks like it's
Indiana, I think.
Indiana, that's what the address looks like. All right, well, I'm glad you've been speaking with him and he has somebody local helping him, because it looks like
Yeah,
that's,
because
he's gonna be needing that.
I informed him that I said I didn't want it to appear like, like a no-call, no-show type of thing, and, he does not caring, and he had asked me to do that, so I said, by all means, I'll help you out.
To your knowledge, I mean, I know he mentioned that the reason that he wanted the halfway was so he could come with the RV. Has anybody been occupying the property to your knowledge?
Not that I know of, no.
Okay, no. Because that's obviously my number one concern is going to be if that thing's not structurally sound, that nobody can even come near it. So it should be probably even possibly roped off.
Well, the portion that's left, it's in the postage.
Yeah, I saw it.
I don't believe that's livable. I don't
Well,
believe
it's not just a livable portion. I just don't want to have somebody come in and think that I'm just going to hang out or come with an RV, or even him coming with the RV and that thing falling apart, because again, it sounds like it was done without the benefit of having an engineering study. So, that's technically my main concern. So, because I think he's going to do what he wants to do with the property and keeping that piece with the overhang for use with his RV, which I don't even know if that's even possible through the city ordinance. Well, let's say assuming let's go with, okay, fine, that's allowed. If he's going to need an engineer, that's probably going to take about, he won't be able to make it in 30 days. It's going to need about 60 days just to even get an engineer out there. And then to apply 30 days, so we're probably looking at 90 days. Do this down about.
That's good.
And that way, and again, just like I know you came in late, but basically what I'm gonna do is when I enter the order, I'm just gonna say come into compliance. And I leave it vague just because there are many options available to the homeowner. For example, that he can just decide to pull the demo permit, because it's just getting rid of the whole thing, period. He could go ahead and stick with the demo permit, but only for half the portion necessitating the engineer. Again, he could go ahead and say, you know what, I'm gonna go ahead and rebuild and send a new building permit to go ahead and do the rebuild and submit it properly. So the order is gonna say compliance, but since you've been here, that's the reasoning behind it. Obviously, stay in touch with the code officer, and he can assist you with all those other nuances, and if additional time is needed, which if it's straightforward demo the way he has it, and let's say it complies with engineering, structural, 90 days should be enough. And even if the whole thing is demo, 90 days should be enough. But if something happens, so long as you've been moving along, your property owner has been moving along and getting into compliance and stays in touch with the code officer, I'll be happy to work with extensions of time as needed, for things outside of, when I'm saying I'm talking about the property owner, outside the property owner's control. So that's pretty much where I'm heading with that.
Okay, concerning that carport thing, is it still up there? Okay, I
Yeah.
wasn't sure. It's been open for forever, so I find that. So-
Well, the problem is not that the carpet was there before, is when there's demolition that was done to the structure without having an engineer certify that it's structurally sound and what pieces can be removed versus not. You could end up with a structure that you think and looks like it's gonna stand up, and if there's a structural component that was removed that was essential, things gonna eventually start cracking until it falls on somebody's head.
Okay, understood.
Seen it happen, unfortunately.
All right, good enough.
All right, so, 90 days, I think you had it was it 250 that you had it at, with the per diem?
That's correct.
All right, I hereby find that there was proper service and that the violation as stated in the notice of violation did exist and continues to exist. I'm gonna order the property owner to come into compliance within 90 days, otherwise face a fine of $250 a day until the violation is corrected. I'm also going to go ahead and grant the town's request for fees and costs incurred regarding this case and bring it to magistrate in the amount of $100. All right, and he'll get an order on the mail.
Okay, good, thank
All
you.
right.
Thank you, Magistrate.
Great, thank you. All right, that finishes up my folders. What else do we have?
Yes, we have one more case, it's just a status update.
Okay.
It's not a new case or anything. As you recall from last hearing, property owner Estero 4148 LLC was here for property 6425 Estero Boulevard. They removed mangroves from their property.
Okay.
And Chad Schutz is here to provide the status update. We just wanted to bring it to keep everyone accountable.
For the
and
status one.
give you the status of what's going on.
This is, let me try everything. Does anyone have a picture of it?
So the order was to come into compliance. It was a canopy of mangroves along the beach theater.
State your name for the record.
Sorry, Chad Schutz. Swear to tell the truth, the whole truth, and nothing but the truth. Long story.
Just sort of firm testimony about to provide the truth, the truth, nothing but the truth, yeah.
Yes,
Okay.
ma'am. Long story short, so it's been with FDEP. FDEP is issuing a compliance assistance offer. That is still in review by the FDEP compliance officer's superior. So we're waiting on that. Also, the property owner has engaged a coastal engineer, and they have submitted some preliminary plans showing the seawall and dock plan with mangrove restoration. So working on them with that. So long story short, they are making good progress towards coming
Awesome.
into compliance.
Awesome. Is that the gentleman over there?
No, I told them
Oh.
it wasn't necessary
Okay.
for them to come in, save them the trip,
The picture is fine.
given that they've. Oh, sorry. Oh, hey, Mr. Jim. Yes, sir. Good to meet you.
Thank you. All right, do you have an estimation on when we should be able to get it soup to nuts?
So they haven't submitted any permitting yet. With the dockage and the marginal dock, I would still say that would be at least a 60-day time frame from whenever they submit to FDEP. It's still not apparent on whether or not they would also require federal permitting. But again, they are making satisfactory progress towards compliance.
Now, in terms of my order, I know today was status, they still have time,
Right, it was 3 months from your order, I believe.
so we're probably ticking on it. All right, we'll do it this way since you've been obviously in touch with them and they're moving forward in coming to compliance. Just reach out, just monitor the time, just in case they need additional.
Yeah, if you wanted to extend it by
Okay.
another 3 months, I think that would be just for them to
Under
work.
this, under the circumstances, is that a recommendation the town is making for the extension of the additional three more months? on the
I
order?
believe that'd be fair.
Okay. Yeah, go ahead, come on up, state your name and relationship to the case. I know I did swear you in, so,
Yes, thank you. Jim Dunlap, 131 Egret Street.
okay.
We're 2 houses down
Okay.
from the Beach Theater. So I've been in contact with Chad over several months when I saw the mangroves being destroyed, taken down, taken
Yeah,
out.
Thank you. Mhm.
I also talked with DEP several times. The thing I wanted to have clarified was the town's ordinances and codes are very clear. If you remove these trees, it's a 3-to-1 replacement. On the other side of the argument, the DEP indicated that if they're putting up a seawall, they can get an exemption from the mangrove removal. Those mangroves were substantial, mature, incredibly beautiful, and all the things mangroves do around the canals. So since that's been removed, it's a substantial difference in the line of sight, the noise, the pollution, all the things you know about. So I want to make sure that I heard it right when you did your hearing here a month or so ago, that part of the ordinance compliance is to them to replace these mangroves, which I know is a difficult task because they take forever to grow. These had to be 50 or 75 years old. I didn't hear that in the original order because they were following the DEP application that said the seawall will accommodate that. So I just wanted some reassurances as representing some of the neighbors that the ordinance, or the requirement to mitigate those mangroves is going to be included in the ultimate resolution of the case.
Well, you probably heard we've been here from the beginning. That's why I
Uh-huh.
always say like the whole about compliance,
Sure.
whichever what compliance looks like, so that it's pursuant to the ordinance. I know that a lot of times when it comes to legal issues, the state is going to trump local government. So it sounds to me, to some extent, so long as it's specifically stated, there has to be a direct contradiction between the state and the ordinance. If the state is silent and the ordinance says something, then it can be pursued. Does Chad any comments to the town in regards to the neighbor's concern?
Your statement or your understanding is the same as the towns as a general rule, particularly since, with regard to mangrove trimming or removal, the state has essentially preempted all local government regulation. We would defer to DEP in the first instance. I do know, with that said, and again, Mr. Schutz can verify for the record, is that as part of ultimately DEP issuing a permit for this, whatever, whether it's the removal or replacement, whatever, with seawalls, that I fully expect, consistent with state rules and regulations, that mitigation will be required as well.
That's what I'm
What that
anticipating, too.
ratio is, I don't know if it's identical to the towns, but ultimately, whatever DEP issues is, as you mentioned, would theoretically supersede the authority of the town to require anything more. But we'll certainly look into that. So, what's the current mitigation ratio, do you know, Chad?
So for FDEP, they will not be requiring mitigation. 1996 Mangrove Trimming and Preservation Act says that if you're doing a permitted activity and there are mangroves in the footprint of that project area, you're not required to do mitigation within the project area. You're not required to do state mitigation for those mangroves in that project area. Having said that, the code is clear that if you remove mangroves prior to obtaining a permit, which they did, then restoration's required.
There you go.
So I would defer to legal on whether or not our code can still require restoration even though the state is not. And also, just because the state doesn't require mitigation, Army Corps does require mitigation.
And they are even higher than
And
the state.
and the state is
so-
not issuing state programmatic general permit, which would give authorization on behalf of the feds. So,
Again, I think that, and we've had similar cases like this, if ultimately the property owner obtains a state permit to, as part of whatever approval, to remove the mangroves, as Mr. Schutz says, which I guess is what they're applying for, is to say they remove the mangroves, or they need to remove the mangroves and because they plan on replacing it with the seawall. So, putting the mangroves back in that exact location is going to be very difficult to do from a practical standpoint. And so I think what we have historically done in situations like this, we've required the property owner who's in violation of the code to pay into, no, we don't have a mitigation fund. I thought I'd asked that question before and been told yes, but maybe I'm wrong. So, all right, well,
All right, so-
then, okay, back to me. If our code requires mitigation, we will require it in some form or fashion.
That
What
is
that
what
form
it's
and
gonna-
fashion is, I don't yet know.
So I think the way that this is gonna fly is, like I said, my order is gonna set compliance, so we'll just keep close tabs on it. At some point in time, that discrepancy, and possible, like, I don't wanna say loopholes, but those little things will be plugged by the city, and the town definitely has an interest in keeping the environmental integrity of our mangroves and dunes and everything else.
Exactly.
So I can pretty much guarantee you that they will look into every possible way to go ahead and do what's the most environmentally friendly thing that they can do. But
Excellent.
obviously within the bounds of what is legally possible, because, just like, I don't know if you have a legal background or not,
No,
but,
banker.
there's
No.
almost a hierarchy of whose law is going to apply first, starting with federal being the first one, and then state, and then local governments.
Madam Magistrate, I've received additional information, so I'll defer to Mr. Schutz. I've said, speak up, there will be mitigation. They have submitted a plan to
Okay.
the town, and as part of town approvals for whatever project they end up getting permitted, they will be putting in mitigation on the property, within the area specified by the town as pursuant to their plans that have been submitted. Correct, Mr. Schutz?
yes, sir.
And I assume under any application for the improvements they're going to make for all neighbors, we'd have some input on sight and sound, line of sights, shrubbery, all the stuff that goes in that, because it's just devastated now,
Yeah,
as you know.
I appreciate that you want 50-year-old mangroves back.
Sure.
It's not going to happen.
I understand completely, but there's a lot of other plants.
We'll be
that can
lucky
substitute.
to get,
That starts
5-foot
getting a
mangroves
little
back.
bit into the encroaching into the property owners, right?
yes.
Yeah,
So
sure.
restoration will be as much as the code allows, and that's all I can promise.
Okay, thank you.
All right, thank you. Let me go ahead and enter an order. I'm gonna go ahead and do a sua sponte order, providing the property owners an additional, 3 months, we said? Additional 3 months to go ahead and keep progressing into compliance at the property. All right,
Thank you.
any additional cases?
No, should I just go over for the record the cases we continued?
Absolutely, please. Let's go ahead and get the ones on there continued or dismissed or complied with on the record, please.
The following cases are continued. Case 20220355, property owner Wilfredo Rodriguez, 5765 Lauder Street. The following 3 cases have been continued. It is the same owner for all three. Prasad Properties, Florida Investments. Case number 20220462 at 1028 Estero Boulevard has been continued. Case number 20220655 at 1046 Estero Boulevard has been continued. Case number 20220652 at 1046 Estero Boulevard has been continued. And the final case that has been continued, FM Beach Delight LLC at 131 Gulf Island Drive, case number 20220569.
All right, I believe that concludes our agenda for today. Thank you all.
Thank you.
All right.
Thank you.